This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
After your losses or last order on 6th May 2025, we find within 45 days, 140 castes have been decided, where normally for one caste 45 days is required for survey. What is electronic speed, indecent haste, notification placed before the state legislature. This is malafide, absolutely malafide.
Central government saying?
Malad
will hear us. Malad will hear us.
I am also appearing for the National Commission of Backward Castes. National Commission of Backward Castes, time and again.
170. How many included? 170?
Not at all. Incorrect submissions are being made. But I am sorry to say, incorrect statements are being made.
I am not submitting included. I am submitting within 45 days after your losses order on 6th May 2025.
76 with respect to 76 notifications have been issued. With respect to 41, the process is ongoing. And who is making this submission? NCBC is making this submission in view of 105th Constitution Amendment. NCBC has no role to play. In view of clause 3 of Article 342A. My learned ASG was making submissions regarding 246.4. 342A3 clearly says, with regard to state list, NCBC has no role to play. This was the scheme.
Very well. Lastly, I submit, Milord, for the last 1.5 years, National Commission of Backward Castes is writing time and again letters to the State Commission and to the Chief Secretary. Every time there is an action that is required, nothing was done. So whether this is a question of national issue or a state list or a central list 64 or 66 scope of Article 246 sub Article 4 will play and then come into play after enumeration decided by the cabinet under the NT 69 or list 1 of 7th schedule. That is a matter to be decided. Now, when the Learned Advocate General submitted this is finality, the notifications, then it has to be stayed. Everything cannot be made infructuous by an executive action. The judicial process.
Very.
And your lordships are aware, when a judgment is delivered in a judicial capacity, judicial process, when that can be frustrated, there are number of judgments of the Supreme Court in which process, not by executive instruction, not by survey, not by issuing notification. This is patently illegal. It has to be stayed.
Yes, we'll come back to you for replies, sir.
Item number 3, my lord.
Let the commission make their submission.
But I have also something to
say. Just one moment. May I just intervene? I just have one small submission to supplement Mr. Sriram's case. I will not take more than 2 minutes, my lord. May I?
Yes, please.
With my lord's permission, my lord. My lord, the fact is, I've heard the Honorable ASG, the Honorable AG. The fact of the matter is, this is a act. The survey that they are allegedly doing is in blatant violation of my lord's order. My lord may kindly have 217. If the lead petition, the page would be 212, para 360. In fact, I will just say, my lord, the fact is, the directions given by my lords on the 22nd of May 2024 order categorically says, and I read, the commission must adopt a fair, transparent and just procedure. Do my lords have the page? It's 212 of the lead petition and it's 217 of Purvi Dash.
You're reading internal page?
No, my lord. It's the one marked in pen. So if my lords have Purvi Dash, then it's 217 and internal page would be 188.
No, we are very well. Internal page of our judgment that you are referring to
would be 212, my lord. This is page 360. My apologies. I don't have the benefit of the lead matter before me. 188. Internal page would be 188, lordship.
All right.
I will just show 3 sentences to show my lord that they themselves agree that they are in blatant violation of my lord's order.
Yes.
Now, the categoric direction rather, by this honorable court is para 360. May I read, my lord?
Yes.
The commission must adopt a fair, transparent and just procedure in the process of identification of backward classes in the state. Public advertisement, present time data, survey of the population as a whole. My lord may kindly mark this. Survey of the population as a whole, detailed scientific survey, methods and comparisons with the whole population are the proper methods to be followed. Now, my lord, the interesting part is that the Affidavit in reply filed by R3, which is the commission, page 14, my lord, and I read. Page 14, they themselves says, when they are asked whether they are actually surveying the whole process, the whole population or not, they say that this exercise, it would also be an absurd and unworkable proposition that every time the commission is considered inclusion, over-inclusion, exclusion of one or multiple classes, it has to embark on a survey of the whole population of the entire state. Page 15, top. The exercise is so large, a scale could only be done logistically, a census by the central government. In fact, conducting a full-scale census would not only involve exorbitant financial costs, but also may delay timely policy interventions. On the contrary, a survey allows focused data collection and is administratively feasible as also economically prudent. Having regard to this, the Commission resolved to conduct the survey using the Cochrane's method for sample size determination of the whole population, which is a universally accepted statistical method. My lord, my humble submission is Indira Sahni judgment, para 798 is very, and 782 is categoric. When it comes to surveys, you have to actually survey the entire population. Para 360, my lords have made it categoric that as of 22nd of May 2024, my lords also wanted that the entire survey of the entire population ought to do it. They themselves in their affidavit in reply have said that they are not doing it. My humble submission is that, my lord, once the methodology of the survey itself is wrong and contrary to my lord's judgment, then all subsequent reports and all subsequent reports are perverse, and all the entire process itself gets vitiated, my lord. It is not only, and to say that the SLP has become infructuous, my lord, is incorrect. Fact of the matter is, today there is no vacuum in law. A 9 judges judgment of Indira Sahni mandates the state to actually conduct a survey of the entire population. This honorable court as well has held that they must survey the entire population. The moment they do this, my lord, the fact that they're not surveying the entire population, the entire process gets vitiated. And my request, my humble submission, therefore, is that a stay ought to be granted. What fell from my lords was absolutely right. That irrespective of what the judicial directions are, the state is ready to do whatever it wants and whatever it deems feasible, irrespective of whether that is in violation of a judicial order. What did fall from my lords was what is in the interim, what is the relief that we are seeking? A, we're seeking stay of obviously this entire process. And regarding recruitment, my lord, because I know that Mr. Datta was very concerned about it. Well, my lord, the recruitments as were done before 2010 in West Bengal, that can continue for the time being. Thank you, my lord.
Very well. My lord will kindly take your lordship's order dated 6th of May. Your lordship had the occasion to consider the directions contained in paragraph 360 of your lordship's judgment. Kindly take paragraph 11. Your lordship will find this at page 38 of my affidavit in opposition.
38.
It starts at page 38. Kindly take page 41.
Yes. Yes.
My lords have got that? I'm sorry, my lord.
Yes.
May I just read out paragraph 11? This court notes that in terms of paragraph 360 of this court's judgment, dated 22nd May 2024 Supra, the commission is to conduct surveys of all backward classes in the state to ensure the benefit of Article 116(4) of the Constitution of India to all such classes and not to any particular set of classes. Mr. So-and-so, representing the commission on instructions from his client, submits that his clients are now willing to do so, identify and conduct surveys of all backward classes in the state. Then your lordship laid down the guidelines, what is to be done. In view of the submissions of the commission and the directions already contained at particularly para 360 of the judgment dated 22nd May 2024 Supra, this court assumes and directs the Backward Classes Commission of the state to publish advertisements of the proposed survey and widely circulate the same all over the state, starting at the village level. The advertisement should spread awareness of the identification and survey to be conducted by the commission so as to enable all the classes and communities in the state who considers themselves, this is most relevant, or are backward, to fill in applications in the format available on the Commission's website or be identified by the Commission. For the aforesaid purposes, all the DMs in the state and the BDOs and the officers under them shall make all efforts to assist such classes in making applications as indicated above. The DMs and BDOs shall themselves assist the Commission in identifying such backward classes. The advertisement shall be published in widely circulating newspapers in Bengali vernacular and any other locally prevalent languages and circulating newspapers within the state in respective districts. The DMs, SDOs in the state shall, through their officers at the village level, shall also spread awareness amongst the backward and uneducated in this regard. Well, this is how your Lordship has explained what is to be done in terms of paragraph 360 of your Lordship's judgment.
That's what we have done.
And we have, your Lordship will kindly take now my affidavit, page 18.
1-8.
1-8.
Yes, please.
Kindly take page 18 for once. With all the relevant annexures, in compliance of the process directed to be undertaken by the order dated 6th May 2025 passed in the said PIL, the Commission immediately took steps to direct the INCA department to arrange to publish. I'm sorry, my lord, your Lordship has got that? I'm so sorry, ma'am. Publish fresh notice inviting applications for the proposed survey, as also inclusion in the state list of OBCs as directed by the order of this court in the newspapers, including but not limited to widely circulated Bengali newspapers and any other locally prevalent languages and circulating newspapers within the state, in order to spread awareness of the identification and survey to be conducted by the Commission so as to enable all classes and communities in the state who consider themselves or are backward to fill in the applications in the format available on the Commission's website. Copies of the letters sent to INCA department are annexed. Now, my lord, kindly take why. Each and every step we have followed. Such direction was complied with and necessary newspaper
Mr. Mazumdar,
Yes,
we have given a substantial hearing to all sides.
right.
Only in reply, we are requested to hear.
My lord, once I'm
Petitioner, there's only one thing we want to ask you.
yes.
As to whether you have complied with our directions in that particular order that you have set out or not,
Yes,
is to be tested and understood understood by us.
absolutely.
Are we supposed to take your affidavit as the sacrosanct final judgment?
No, cannot be. Can never be.
Please give us an opportunity to have
Lordship will
hear
kindly-
all sides on
Only one
affidavits.
submission, my lord.
But we are, if you have noted the tenor of the order
Right.
that you claim to have complied with, which we will assume that you have complied with,
Right.
at least prima facie.
Prima facie, my lord.
The tenor is first to see the process that you undertake, the propriety of the process.
Right, man.
Now, in addition to that, what other parameters you have included in your surveys, we have to examine.
Absolutely.
Let us do that but then if the state jumps the horse at a knee-jerk reaction, issues notification based on your recommendations, where does it leave these writ petitions? Please tell us that.
My lord, may I just answer to your Lordship's query? My lord, it has fallen from my lord that executive orders are being revived. My lord, because my lord, in view of the
No, not from us. It is an argument
this
made
is an
by,
argument, it is an argument made on behalf of the
it is still an executive order as we
an
understand
executive
it.
order. My lord, the commission is not responsible for issuing
No.
notifications.
So,
But my reading of the
so we
notification.
are only seeing that, yes, you have filed an affidavit enumerating what steps you have taken
Yes.
in terms of our order.
Right.
We are required to test that. We are required to hear them, the union or whatever, whatever commission, especially the state government. Now, Mr. Dotto, we ask you this. If as a knee-jerk reaction, you issue notifications and you declare all these classes as OBCs, where does what is left for us to decide?
Milord, 2 or 3 submissions on that. Number 1 is, Milord, so far as, Milord, your Lordship's orders are concerned, Milord, it is pending before the Supreme Court. Second is, Milord, I can well appreciate, Milord, the concern of the court. The second is, Milord, had we not gone before the Supreme Court, what were we left with? We were left with nothing but to act in terms of the order of this Honorable Court. Therefore, Milord, we, according to us, we are acting in terms of the order of the This
Are
honorable.
we not entitled to look into the propriety of the submission?
Yes,
We will presume that you are doing
Yes.
so.
so, my lord,
But then, given the huge controversy that this matter has seen over the years,
yes,
now, and also the fact that a majority of the classes struck down by us are re-included, maybe for very good reason,
yes,
maybe for applications received, surveys conducted. We want to see the nature of the surveys conducted. We want to see the data that was available before you. We want to see how much of the state's population, what is the percentage of the population that you have surveyed, what is the level of backwardness. And most importantly, let us assume for the sake of argument that the commission has done everything in letter and spirit of our order. Let us start with that proposition.
right.
There is a second part that the commission is required to do, is to see whether these classes are appropriately represented
Yes.
in the state.
Well, it's
Now,
done.
one minute,
Done.
Mr. Mazumdar.
Done.
We are now.
Done.
This exercise is also to be undertaken
Done.
and
Done.
tested before us.
Tested.
We just want to see it. Now, if you declare and start recruiting, and tomorrow we have to strike it down, then what will happen?
Now, my lord,
We are back to square one.
may I say this?
And it is not as if these classes, a majority of the classes that you have recommended, are on the streets. They have benefited from a reservation for about 15-20 years, which we have found to be incorrect and illegal. Good, bad, indifferent, they have benefited. They are not on the streets. Today, what you are looking at is fresh recruitments and fresh admissions for colleges and universities. Admissions for colleges and universities provided for. One methodology has been evolved by a single bench, which we prima facie find to be appropriate. All right. But even before we test the recruitment and declarations of OBC, if you start recruiting, where does the leave the writ petition? They are all infructuous.
Now, my lord, may I, my lord, keeping in mind, my lord, the concern of the court, address your lordship's my lord on that. My lord,
Day after tomorrow. বৃহস্পতিবার বলছি। On Thursday. Thursday 2 p.m. we keep it only for consideration of the issue as regards this notification.
my lord, on the issue of
And
grant of any interim
like
orders,
to
your lordship will be
your,
considering
uh,
day after tomorrow.
By Thursday,
Yes, I shall make my rejoinder application there. If there has to be other petitions which will have to challenge the rest of the reports which have been made part of, I'll complete my pleadings part by then. But kindly see in the meantime, two defenses which have been.
we are only keeping it for consideration as to whether we want to pass an interim order at
Right.
all or not.
Very, very.
So whatever pleadings for these applications, let us not increase the applications. Whatever pleadings are left, they have to file an opposition to your two applications. You have to file a reply to their affidavit in opposition. Please do it by Thursday. Exchange it. We are keeping it Thursday 2 p.m. My learned brother has another engagement, administrative engagement.
Between today and Thursday, if the recruitment notifications is acted upon, I'm only trying to keep the cause of action warm.
Not to worry, Mr. It's 2 days, heaven and earth won't fall. And if there is anything that is precipitative that is done, we always have the power to undo it.
17th.
The date given the portal is being open tomorrow.
Let it be open. If anything precipitative is done, eventually we have the
court
power
can
to undo
undo
everything.
everything.
Daniel,
Court can do repetition. I'm saying, your lordships, that we have
Don't
suffered from 2010 to 2023.
2 days more.
Now, this
Now,
is
my lord,
again,
my lord, who has suffered
Is
is not before the court.
we were before the court.
No. The person suffering is not before the court.
We come back tomorrow 2 p.m. We will
Tomorrow.
No further pleadings required. Whatever, if you want to file in the meantime, well and good. We are keeping it for tomorrow at 2
We'll
p.m.
Very well.
consider the interim prayer.
Very
which
well.
has been
Very,
made by
very,
Mr. Dotto will be
Definitely.
making.
We will only allow Mr. Dotto to make submissions and Mr. Ram to make some further in
I'll
reply.
take 5 minutes.
File,
We have
my
got
lord,
the
if we are able
union,
to
we have
file,
got the
if we
commission.
are able to file pleadings, my lord.
Sorry,
If we are able to file pleadings tomorrow,
by
then
tomorrow.
yes,
No, tomorrow.
I don't think they'll be able
I
to
won't
file
be
any
able
pleading by
Because I'll rely on their materials
my lord,
to
we will try.
traverse every
as
argument.
you
that-
please.
Yeah, yeah.
If you can do it, let us not do it. We will. It is only an ad interim order. We will be if at all.
If at all we want,
If at all we are satisfied, we may consider. Otherwise, we will hear it after exchange of affidavit as soon as possible.
Maybe given the liberty of appearing online tomorrow, I have to travel.
Oh yes.
I'll seek a law.
no online. You have to be offline.
Anyway,
Due to-
most certainly.
Due to paucity of time, the learned advocates appearing for